Okay, good morning, everyone. My name is Ron Youssef from the Emerging Technologies Practice at Arnon Tadmor-Levy. I will be your moderator for today's session. Let me first thank you for joining our webinar with the leading German law firm YPOG and in cooperation with the GCs for GCs community in Israel. We are excited to have you. In exactly 4 months from today, the EU Digital Operational Resilience Act, also known as DORA, will become enforceable in the European Union. Today in our webinar, we will discuss what this means for technology providers to European financial institutions. I will give you a brief overview of today's agenda. We will start with a short introduction by YPOG, partner and head of Emerging Technologies Practice at Arnon Tadmor-Levy. Following that, I will give the floor to our colleagues from YPOG, Carol Aratke, co-managing partner, together with partner Luz Schreiber and Sarah Appenburg, and senior associate Felix Pinkepunk. They will discuss the DORA regulation in depth. After their presentations, we will have a Q&A session. I invite you to submit at any time during the webinar questions through the Q&A function below. I will be happy to present those to our experts from YPOG. We will do our best to address as many questions as possible during the Q&A session. In any case, this webinar is being recorded, and the recording will be shared with all registered participants after the event. I've spoken enough. It is my pleasure to introduce our first speaker, YPOG. Roy, the floor is yours.
Hi, good.
We're experiencing a little technical issue, so
I'm back. Can you hear me now?
Yes.
Okay, sorry about that. Technical issues happens all the time. So good morning, everybody. It's actually a pleasure to host this event. First of all, I want to thank our partners, Yoamashim for Yoamashim, Lemani Yoamashim, and Yael for helping us with getting this spread out as much as possible. And for YPOG, I'll say maybe a word about that in a minute or so. This event is focused on DORA, the Digital Operational Resilience Act, which passed almost 2 years ago. Enough time to prepare, but we Israelis tend to prepare in the last minute, so it's actually almost the last minute, and time is up. And it will enter into force very soon. And you'll hear about some of the details of DORA and the regulation in a few minutes. Some say that DORA is applicable to EU financial institutions. This is, of course, true, yet its applicability is much far wide when you look into the details. Also to service providers, to financial institutions in the EU, such as tech supporters, data analytics, payment processing, cloud computing services, even hardware providers. And this pretty much includes everybody who's participating today on the call, also as attendees. We've already seen the first signs of DORA implication, although it's not entered in force yet in commercial agreements. We've received at least one client who actually came up with an addendum to a commercial agreement, incorporating some of DORA's provision into the agreement, which requires diving in details into some of these obligations and negotiating some of it, and also a lot of preparation on the client side. And the more you prepare, you actually can get it a bit better when it actually comes into force. We also see this something that can come up in due diligence in the financing round. Its applicability to startups or growing companies going into financial rounds. And this question will come up from investors, especially European investors. So we're going to see it all of the way. We see specifically in our emerging technologies department, we see our role more as assisting in the commercial issues, preparing for the regulation, of course, financing rounds. And in times where there are complicated questions, referring to partners like YPOG, and we're happy to be able to collaborating with YPOG, a leading force in Germany, also in Europe. And a good partner to actually dive into some of the complicated issues that this regulation brings about. Not only this regulation, but others. But this is actually a great opportunity for you to hear directly for some of their expertise and what's going to happen in Europe. So without further ado, I will leave it to Ran and our friends from YPOG to lead us into the DORA regulations nuances.
Thank you, Roy. Without further ado, Carola, please go ahead.
Yeah, hello everybody, and thank you for having us here in this great webinar. So YPOG as a law firm has a strong focus on future technologies. So I think this is the DORA regulation is in our sweet spot. And I don't want to use up too much time in introducing us. Who's interested in it can request the presentation and will find our contact details afterwards. So Lutz, when I may I ask you to share the presentation so that we can immediately kick off to make the best use of our time here. Yeah, if you can swap to the first slide. Yeah, what is DORA? Yeah, DORA actually is as Rui already said, is the Digital Operational Resilience Act. And what is the aim, the objective of this regulation? This regulation ensures that financial entities, and you'll be here in a second, and Rui has already mentioned a lot of them, that financial entities, and it's meant in the broadest sense, within the EU can withstand, respond, and recover from all different types of disruptions, cyber attacks, etc. And because of the importance of the information technology in Europe, so the ICT, which is information and communication technology to be exact, in order to ensure that all the financial entities are resilient enough and are not subject only to national laws anymore, the EU came up with this European-wide regulation, the DORA regulation. And the aim is, as I said, to harmonize the entire national regulations, which had different standards. So in Germany, financial institution had already very high standard. Nevertheless, they need to amend a lot of things in order to respond to the new upcoming DORA regulation. So what does DORA regulation mean? It's not just a regulation. A regulation in Europe means that it's directly effective in all European countries. So there is just one level playing field in Europe when it comes to these kind of companies, so the financial entities. So there is no arbitrage possible anymore between one and the other country. So we have this DORA regulation as a level 1, we call it level 1 regulation, because this is the act that is directly effective in all European countries. But as a regulation is always a bit high level, we have a lot of different level 2 and level 3 regulations, we call it. So the level 2 regulations are more detailed regulations. They are so-called RTS, so regulatory technical standards, which are very detailed. And the same is then afterwards, not only regulatory technical standards, but the way how to implement these regulatory technical standards are covered in an own delegated act, the so-called implementing technical standards, or ITS. So you need to look not only into the DORA regulation, but also in the delegated acts. And in order to ensure one level playing field within Europe, it often comes up that nevertheless, despite of having this act and the delegated acts, there are still a lot of upcoming questions, how to deal, how to implement the act, etc. And therefore, we have this level 3 regulation. These are so-called guidances and recommendations issued by the European supervisory authorities, which are in our case 3 authorities. It is the ESMA, the EBA, and IOPA. So it's for the banking association. I don't spell out all the names. It's for the financial services companies, the banks, and the insurance companies. And they have one giant super authority, which is the ESA. And the ESA is taking care that also the acts and delegated acts are implemented in the same standard, in the same way. So we have Q&As in all different kind of upcoming questions that are supposed to be solved in the same way. And this is taken care of by this ESA authority, or authorities to be very precise. So who is affected? It has a very broad range. And I think this is super important to notice that we have some directly affected, but also a lot of, and this will be probably even more important for you, a lot of indirectly affected companies. So the directly affected companies, as Rui already said, are financial entities. And we named already some of these: credit institution, payment institutions, crypto service providers, but it's meant in the broader sense. So whatever you can think of, trading venues, etc., they are all affected, directly affected by this regulation. On top of that, not only financial entities are affected, but also the so-called critical information and community technology providers. So all the services or all the companies that provide services to financial entities that operate in the EU, that is important. So the scope is, of course, focused on the European Union. They also will be subject to the oversight by this European supervisory authorities. So it's new that also the critical ICT providers will be directly monitored and supervised by the ESA. But this is not all. So we have also some indirectly affected companies, and these are not the critical ICT providers, but the normal ICT third-party providers. So if companies provide services, so companies means, of course, information and community technology companies provide services to financial entities or to critical ICT third-party providers, they are also covered and affected by this regulation. You will hear in a second what does it mean, what is affected, what do you need to take care of. But it's very important to understand that also non-critical ICT providers that provide services to the directly affected companies are absolutely within the scope of the regulation. And it goes a bit beyond, we haven't mentioned it here, but maybe it's important to understand that also subcontractors. So what is meant by subcontractors? Companies that subcontract with a critical third-party provider are affected by that. So there is a differentiation between ICT third-party service providers and subcontractors. Subcontractors only providing services to ICT third-party providers are also within the scope. So there is a chain of kind of responsibilities. So whenever in the end you touch indirectly financial entities or these critical ICT third-party providers, you're definitely within the scope of the DORA regulation, and you need to fulfill all the requirements that we will briefly highlight in this webinar. So it's important to understand that it's a very broad range. It goes beyond what you probably might know. These kind of outsourcing requirements, material outsourcing requirements, you're already probably used to when you kind of have touch points with financial services institutions. It's not limited to that to this material or critical outsourcing. It goes way beyond and affects a lot of more companies. And you will hear in a second what is affected. So Lutz, if you turn to the next slide, please. And over to you, Felix.
Yes, thank you very much, Carola. So yeah, now that we know what DORA is and who it applies to, let's look at the 5 pillars of DORA. Yeah, the first element and one of the cornerstones of DORA are the provisions on ICT risk management. And in this aspect, DORA requires financial entities to put in place an internal governance and control framework. Yeah, what does that mean? In simple terms, financial entities must have a documented description of who is ultimately responsible for ICT risk management, who does what work, and yeah, who checks or controls the quality of the work. And in this context, DORA introduces 2 significant changes to already existing EU regulation. First, the management body itself must define, approve, and oversee ICT risk management, meaning that it can no longer be delegated fully, for example, to a CISO who is not itself part of the management body. And second, financial entities must establish a new role or function, which is the ICT third-party risk management manager, who is exclusively responsible to monitor the contractual arrangements concluded with ICT providers. So yeah, this leads us to the ICT risk management framework itself. So DORA goes into detail of what an ICT risk management framework at least has to include. This is the Digital Operational Resilience Strategy. These are various policies, for example, access and identity policies, IT operations policies, procedures, as well as protocols and tools. And to specify the content of this documentation, the ESAs have published regulatory standards, which are very descriptive and really detail the specific content the policies must cover. So that means there's not really great leeway on the part of the financial entities in terms of the content and structure of these policies. The second pillar are the provisions on management process for ICT-related incidents, for example, emerging from ransomware attacks or IT migration failures. This includes defining what an ICT-related incident is, the classification of criteria in order to assess the consequences or the impact of an incident, and the recording and reporting of the incident to the regulator. Another pillar, the fourth pillar on the slide, addresses the digital operational resilience testing. As for types of testing, DORA defines two categories. First, basic tests, which all financial entities have to conduct. For example, source code tests, performance tests, etc. And the so-called or the advanced so-called threat-led penetration tests, which only apply to significant financial entities. And whether a financial entity is classified as significant will not be determined by the financial entity itself, but by the regulator based on various criteria, for example, the systemic risk. So when it comes to threat-led penetration tests, DORA introduces a new obligation, which is not part of the current regulation on outsourcing. It makes clear that financial entities need to get their ICT service providers involved in the threat-led penetration tests if the function, if the IT services are part of the scope of the test. And this brings us to the pillar in the middle, the ICT third-party risk management. Now, financial entities can have the best ICT risk management, incident management, testing procedures in place. However, all of that doesn't mean much if financial entities heavily rely on ICT providers that don't follow proper IT security standards themselves. So with that in mind, DORA requires financial entities to treat risks brought by third parties as their own risks. In other words, DORA does not impose any direct regulatory requirements on ICT providers. Instead, it requires the financial entities themselves to first conduct a risk assessment, meaning identify and assess all the relevant risks in relation to the ICT services, undertake due diligence on the ICT provider, and then finally implement key contractual provisions in the contractual arrangements relating to the ICT services. And these contractual provisions are detailed in Article 30 of DORA. And this includes, for example, audits and access rights of the financial entity, as well as the regulator, conditions regarding any subcontracting by the ICT provider, including ensuring that subcontractors meet the same standards as the ICT service provider. That means DORA really covers the whole supply chain. And terms for the termination of the contract, including handling of the data, the transition of the services. Yes, so the required contractual provisions for critical ICT services largely align with existing European regulation on critical outsourcing. This means, from our experience, that for ICT providers already delivering IT services that are currently classified as critical outsourcing, the impact of DORA will be rather minimal. However, Also, based on our experience advising financial entities, we see a significant need for adjustments on ICT contracts currently classified as non-critical outsourcing. And that is because DORA introduces substantially more mandatory contractual provisions on non-critical ICT services. So, for example, contractual arrangements for non-critical ICT services have to regulate the obligation for the ICT provider to assist with ICT incidents at no extra costs or at pre-agreed costs, have to include the requirement for the ICT provider to cooperate with the competent authorities, meaning the regulator. And these are all contractual provisions that the current regulation on non-critical outsourcing doesn't contain. So I think in the interest of time, I'll skip the pillar on information sharing since it's not really relevant to ICT third-party providers, and pass it on to Sarah.
Great, thank you, Felix. So, having covered the content of DORA now, I want to continue with some details on relevant dates and documents specifying the DORA. As you can see on the slide, DORA entered into force on January 16, 2023 and will be fully applicable on January 17, 2025. And during the 2-year time implementation period, it was not only on the financial entities and ICT providers to implement the requirements of DORA, but also on the regulators to specify such requirements. As Carola already said, these specifications were prepared by the European Supervisory Authority in the form of RTS, describing the what needs to be done, and the ITS, describing the how it should be done, and also by guidelines or acts by the European Commission. Below on the slide, you find an overview on the published specifications, which can also be found on the European Supervisory Authority's website. And the first batch of these specifications, which can be found on the left side, were provided in January this year, and the second batch in July this year. So while the first batch has already been finalized and adopted, the second batch is still in drafting mode and will be finalized later this year. And as the RTRs and ITS are quite relevant for the financial entities and the ICT providers in respect of the what needs to be done and how, the full picture on what to do has basically been delivered in July this year. And this is also why financial entities and ICT providers are now working in a very high pressure to meet the deadline of mid-January 2025. The last relevant date on the slide I want to make you aware of is the designation of ICT providers to be a critical third-party service provider. This designation will be done by the European supervisory authorities after January 2025. And I will go into more detail on this topic later, so we can move on to the next slide. So one topic which is very important and which was already mentioned also by Carola is the scope of application. When we are talking about financial entities, we do not only mean the typical payment institutions or credit institutions, but all of the 20 categories of EU financial entities shown on the slide. And these financial entities are also listed in Article 2, Paragraph 1 DORA, so you can read through this list. What is important to know, though, is that DORA does not apply to all financial entities to the same extent because DORA adheres to the proportionality principle. Therefore, some sections of DORA do expressly not or only to some extent apply to micro-enterprises. This means financial entities that employ fewer than 10 persons or whose annual turnover or balance sheet total does not exceed 2 million euros. So in summary, the scope of application of DORA is very wide. and goes beyond the current regulatory frameworks in the EU and also in Germany. Moving on to the next slide. We also want to make you aware that not only financial entities, but also ICT providers serving financial entities are covered by DORA. Already mentioned also by Felix and Carola. This application of DORA to ICT providers follows from Article 2, paragraph U DORA, and it applies partly directly with regard to critical ICT third-party service providers and partly indirectly. So due to the many requirements of DORA, it is of course important to know whether a provider is considered as ICT provider under DORA or not. And I need to say, as the definition of ICT services is quite wide, I copied it here on the slide, most providers of IT services will fall under these definitions. For assistance purposes, the European Supervisory Authority have included a list of exemplary ICT services in their ITS, which I have linked on the slide. So if in doubt, I really recommend reviewing this list. What might be of interest is that neither the DORA nor its specifications provide for the right or of the affected service provider to push back or challenge the designation of a financial entity that the service provider is an ICT provider. However, in our view, this should not prevent from the affected service provider from reaching out to the financial entity and asking for information as to why they have been classified as an ICT provider and challenge it, particularly if the respected services are not covered by the definition and also not in the ITS I linked here. So coming to the last bullet point on the slide, as mentioned, DORA divides between normal ICT third-party service providers and critical ICT third-party service provider, the so-called CTPP. And the CTPP will be designated by the European supervisory authorities beginning of next year. And the designation process is based on criteria stated in Article 31, paragraph 2 DORA, and also specified in an accompanying RTS. If an ICT provider is designated as CTPP, it will be directly monitored and can be sanctioned by one of the European supervisory authorities, which will be the lead supervisory authority or the lead overseer. Also, financial entities may only enter into contractual agreements with CTPPs if the CTPP has established an affiliate in the EU within 12 months after designation. So this is a really important point to be considered. What is also important is that providing critical or important functions is not the same as being a CTPP. Whether an ICT provider is providing critical or important functions is based on the assessment of the financial entity according to the DORA definition of critical or important. However, the designation to be in CTPP is based on the assessment of the European Supervisory Authority and will only apply to ICT providers which are so critical that the failure would lead to a large or would to a large extent trigger the stability, continuity, or quality of financial services in the EU. And to my understanding, those providers would, for example, be the typical hyperscalers like Google, AWS, and Microsoft. So I hope this gives you a good overview, and I will pass on to Lutz now, who will cover more the topic on what to do now.
Thank you, Sarah. Now that we've heard which financial services entities and ICT providers are actually falling under DORA, and perhaps you've realized that it also applies to you, you might ask yourself, what are the measures that you need to take now to be in line with DORA in time until January 2025? For that purpose, we've collated a very high-level overview of the measures that you need to take and the things that you need to consider. First, we suggest you perform a gap analysis. Review current processes, your documentation, even agreements. As we've heard, there are also contractual requirements that you need to consider to identify any deficiencies when it comes to DORA compliance. We heard there are a lot of requirements, operationally, technically, contractually, so it may sound like a lot of work. Actually, it is, but don't be scared. There's still time. As Roy said, I think there is still time. It's 4 months, but you need to take care of it, get on top of things, and look into the specific issues. But DORA is not a new paradigm. It's not something totally new. It's more sophisticated, more thorough. It shall put an end to fragmented regulation for the goal of information technology security and resilience. But even before DORA, financial entities and financial service providers were not under no regulatory regime. We've heard that before. EBA, EIOPA, ESMA, they all had guidelines out and requirements that you need to consider when you provide financial services in the EU. Therefore, the importance of the gap analysis is not starting from scratch, but actually finding and realizing and analyzing what you currently have in place, see what you need to do to uplift your security framework and to comply with DORA until January. You need to address these identified gaps. You need to implement the necessary internal processes, perhaps create new guidelines and documentation by January 2025. In addition, you will need to most likely modify some of the processes. We've heard there's some new processes or more strict processes. Felix said that at the beginning that were implemented. There will be new roles for management, or the some might call it the kind of the DORA officer that you need to appoint to overlook the risk and manage it, the risk control function. And you will also need to adapt the agreements that you have in place, particularly if you're a financial institute with your ICT providers, or if you are an ICT provider with your subcontractors. And don't wait for standard contracts to be published. There will be standard contracts eventually coming out from the Commission. They're not yet there. They're not officially launched. There will most likely not be enough time to adapt all of them. So the process will most likely be renegotiate your agreements and then perhaps renegotiate again if the standard contracts say something different. But even the authorities are not yet up to speed with everything and are aware of what eventually will be what you need to adapt. So don't hesitate, look at the requirements, try to adapt and renegotiate all the documentation that you need. And perhaps then it will be a process, and then reconsider when the new standard contracts will be out. And for the renegotiation and update process, we've already heard there are actually quite a lot of issues that you need to consider. We heard there will be minimum contract requirements. Service descriptions need to be quite precise and detailed for the risk analysis and due diligence processes, the subcontracting, business continuity. There's a lot to consider. Even termination, of course, has been more strict and onerous for the providers. So you need to look into that as well. And in order to do that, we suggest that you, of course, follow ESA's specifications, because these are the basis for implementation. Sarah just said that as well. The regulatory technical standards, the what, the RTS, the implementing technical standards, the how, and of course also the guidelines and recommendations as a basis for your next steps. And if you're in doubt, we suggest that you may also consult the BaFin resources, the German supervisory authority for banking and financial industry, because they have it's called a DORA hub with lots of information on it, including resources for a variety of topics relating to DORA, and actually also a very helpful list of minimum contract terms, for example, where you can look all the requirements that you need to put into your contracts as a minimum requirement. The link actually will be in the document, so you can tap on that and then get to the relevant documentation. We hope this gave you a brief but helpful overview of application and details of DORA. And I believe there's now time left for Q&A. Back to Roy.
Thank you so much, Lutz, and the entire YPOG team. This has been an insightful presentation. Thank you. As you said, Lutz, we will now move on to the Q&A session. I implore all attendees, you can continue submitting questions through the Q&A function. We will try to address as many as we can in the time we have. We have received several questions in advance. Maybe I'll start with one of those, and then we can continue with some of the questions we've received in the Q&A. We have been approached by several tech companies in Israel that have been approached by their clients in Europe, saying that DORA now demands them that they would comply with appropriate information security standards. That's for the tech companies providing services to financial institutions in Europe. So when we went to DORA and we noticed that there's no definitive answer in DORA as to what amounts to appropriate information security standards. What measures or standards actually satisfy this obligation. I'd be happy if one of you can shed some light on this issue.
Yeah, I'm happy to do that. Thank you, Ron. As you already mentioned, the DORA and the regulation and even the associated acts actually don't provide specific specification on applicable standards or even an exhaustive list of required standards. So it's difficult, and I totally understand that that's an important question. So it's difficult to assess what would be actually appropriate. Our thoughts on that are that having specific certifications, which are typical for the industry, even the past, to prove information security, are always helpful and are most likely recommended to have in place to prove that. In the end, and I'll come to which we suggest, but I guess it's the most likely. But it's in the end, it will again be a moving target. There will be suggestions most likely sooner or later, and there will be an industry standard of certifications, kind of as a portfolio of certifications and standards that will need to be in place to prove that. Our suggestions would be the ISO 27001, which is, I mean, this is the standard for information security management systems, very, very common in the industry. So this is a typical one. The ISO 22301, so 22301, sorry, it's a business continuity management one. So that's also very common. And of course, the SSAE 18 SOC 2 Type 2, privacy and security controls, protecting confidential customer information and management. So I think if these are in place, at least there's a strong indicator for appropriate standards and for appropriate processes. As I said, in the end, it will be a moving target, and most likely we think and we hope that once it comes into practice, it will evolve, and there will be standards more or less in the future.
Yeah, one additional sentence just to that. I think that's what the Q&As will be for in the end. So we would recommend to kick off exactly with these standards and watch the Q&A guidelines that the ESA will publish in future, because this is exactly what we said at the outset, that one level playing field needs to be created. And I think the European authorities will look at what has been done and will be done, and that we will get more precise information on this over the time. But starting with these standards, I think, is a very good starting point, and then look at these kind of Q&As, ESA guidelines, guidances, etc.
Thank you. Thank you so much. One question we received by attendees is what is the relationship between DORA and EU member states legislation? I will add from perhaps a perspective of an Israeli ICT provider with a client in France or Germany. What if they comply with German or French law? Could they still be in violation of DORA?
I can pick it up if you want to. So of course, DORA is now the overarching regulation. So if you are, for example, in contact already with a German financial institution, you are already subject to the so-called BAIT standards when you're dealing with financial services companies and entities, and this standard will expire. So this will be kind of covered now by DORA. So also in our new licenses procedures, where we, of course, need to cover IT security, BCM, risk management, outsourcing, all these issues, we are already discussing nowadays a standard that is the DORA standard, because now doing an application based on the expiring BAIT, so the current German regulation, will not fulfill the standards in future. So it's a good starting point, and you will cover, as Lutz said before, already a lot of topics, but nevertheless, you only need to comply in future to the DORA regulation. So there is no use to really look into the national regulations anymore. So the same applies to France and to other European countries. So after the 17th of January next year, you only need to comply and have to comply to DORA standards. Complying to or having fulfilled the current national standards is fine as a starting point, but not enough anymore. So all the German financial regulations currently do gap analysis and also force a gap analysis to get gap analysis from their providers in order to fulfill the DORA standard in future.
Thank you, Carola. One more question we received is, well, DORA obviously applies to fintech companies, for example, but will DORA affect Israeli banks or financial institutions which do not provide ICT services but do provide banking services to EU players, and for that purpose will obviously have to interface electronically with EU banks and other financial services providers?
Sarah, you want to pick up the question?
Actually, it was quite hard for me to understand the question. Maybe it's my...
I'll briefly repeat it. It's okay. So the question is, will DORA affect Israeli banks which do not provide ICT services but do provide banking services to EU players, and for that purpose interface electronically with EU banks and other financial service providers?
So I think we need to, this is a setup we need to look into more detail, because this is sometimes like this, sometimes like that. So I think we can respond to it afterwards, but I think we should pass on to another question now.
Yeah, I think it depends a bit on what kind of services you are providing. Therefore, it's very hard to say it in a high level. So, of course, generally, as a EU bank, you are not in, as a non-EU bank, sorry, you're of course not within the scope of the DORA regulation itself because it's affected to EU financial services institutions. But it depends on what kind of service you deliver to other financial service institutions, how you interact with these EU-based financial services institutions. So you should at least double check if you are indirectly affected. So you will not be directly affected to it because you are outside of the EU. So that's the good sign, but you should nevertheless double check if your EU institution, financial services institution you interact with will force you to also indirectly obey to the regulation because of the kind of services you provide. And therefore, it's hard without getting into more details to say you are out or within the scope of the regulation, but at least you should please double check what kind of services it is. So happy to have a conversation, a follow-up conversation on this to really make sure that you are not within the scope of DORA.
Thank you so much, Carola and Sarah. One more question we received relates to risk assessment. Can you elaborate on the business continuity requirements part of DORA?
Lutz, you want to pick up? What business continuity requirements means under DORA, or shall I?
You can.
Okay, so of course, I think business continuity are the same standards you currently have already. So there is no special on top. So it depends, of course, what you have done up to now. So if you're already part of, for example, if you're already dealing with German financial institutions, you might be already forced to be subject to the BAIT, so the German regulation I have mentioned before, where you're already subject to business continuity models, exit plans, etc. So of course, business continuity, you will be part of the business continuity system, the business continuity planning, and of course, you are already currently doing this business continuity planning jointly. So if I'm a German financial institution, I use a third-party provider in one of my core areas. So the so-called critical, or in the past, material outsourcing. Of course, I have the outsourcing officer that needs to monitor that my third-party provider can be substituted easily. So it is very closely connected to the outsourcing questions. And therefore, of course, as a financial services institution, so we are the regulatory lawyers here, so we're coming from this financial services institution side. So the financial services institution needs to ensure how to, of course, how to monitor their own business continuity, but then how to substitute third-party providers. And so what do? They have RFPs. In the framework of the RFPs, they have set certain requirements. So KPIs, they monitor the KPIs, make a selection, and then choose one service provider. In the end, there are, of course, other companies they have monitored and will substitute in case the one provider is not willing or able, of bankruptcy, insolvency purposes, is not able to deliver these services anymore. Of course, you need to substitute and need to convince then regulators what you have done in order to ensure that if your provider is not able to provide the services anymore, that your overall services will not be affected. And then, of course, you need plans, how quickly you can substitute, how much time it needs, what does it mean for your IT setup? Do you have the right IT setup in place in order to easily connect your new service provider, etc., etc.? So there are a lot of details, a lot of planning, a lot of policies you need to implement in order to ensure that if one provider doesn't deliver services properly, meaning doesn't meet KPIs, and this needs to be monitored again by the outsourcing officer and in future also the DORA officer, that these KPIs will be met. And therefore, of course, there is a whole chain of policies you need to implement in order to ensure that your third-party service provider fulfills all the requirements. Or if not, that you can substitute, so for business continuity reasons, this provider. And as an institution itself, so this is a different part, which is probably not interesting here for this group of people. But of course, there are a lot of policies you need to draft and procedures out of these policies you need to implement in order to ensure that you have proper business continuity plans. And in the end, also exit plans in case the provider doesn't fulfill the services. So we're drafting all these things. So if you need more details, I don't want to spend too much time on this point right now, but we're happy to discuss it in more detail with you.
Yeah, and quickly, thank you, Carola. And quickly to add to that, the requirement is actually that there will be seamless operation of the business. So no business continuity in. We may have a new setup in 3 weeks, 4 weeks, whatever time. Seamless operation is the general goal of the DORA. So the requirements are actually very high, and the things that need to be considered so that you can actually switch in case of insolvency or in case of any outs. So if the service is not provided anymore, are actually quite high.
Thank you so much again. Our time is actually nearing to an end. I want to thank all participants for engaging. Yes, sorry.
Can maybe we have another. I'm just think a few questions related. Maybe it's a quick answer, so maybe we can cover that. A few questions related to whether providing services to government, local government, tax authorities is covered by DORA. My assumption is a few of the participants are actually service providers of local governments or governments in Europe. Would that DORA be applicable to providing services to government agencies? You're on mute.
Sorry, sorry, I needed to unmute. So generally not, because it's just for the government. We are not talking for providing services to financial institutions. So we have not made aware of that also indirectly, because it touches somehow everything then in Europe, that the understanding is that broad. So if it's really limited and has no direct contact to a financial services institution, it will be out of the scope of the DORA regulation. But as whenever you provide services to a financial services institution itself, and as part of their internal accounting, whatever system, we need to have a closer look into it. It might be still out of the scope, but there it makes sense to have a closer look into it. If there is no touch point to financial entities as defined here, it would be definitely out of the scope.
Thank you. Thank you, Carol.
Okay, so we are actually very close to finish. I want to leave just a couple of minutes to thank all participants for engaging with questions. We know that we were not able to answer all questions. We want you to engage with us. Just send your questions, the questions you find that won't answer, that we had no time to touch upon. You can send us to the email, to us, to me, Ran, to Roy, and to our YPOG experts. I want to thank Carola, Lutz, Sarah, Felix from YPOG, Roy Kedar from our team at Arnon. I want to thank Yomashim Leman Yomashim, GCs for the GCs. Thank you for your participation. We hope you found this webinar informative and helpful. And please do not hesitate to reach us out, and have a great day. Bye-bye.
Thank you.